I will not officially start until we've disabled the alarm system, so we'll just stand at ease, everyone, please. All right. On that happy note, I'd like to welcome you here this morning. I'm Interim Commissioner Holly Cheeseman. I'm joined here by my esteemed colleagues, Interim Commissioner Beecher and Interim Commissioner Smith. I'd like to welcome you to this procedural conference as I collect all the paperwork. We're here today for docket number 25-11-13, remand of the application of the Southern Connecticut Gas Company to amend its rate schedule. And we are conducting a procedural conference. As the parties are likely aware, the Superior Court for the Judicial District of New Britain remanded the November 18th, 2023 decision in docket number 23-1102, application of Connecticut Natural Gas Corporation and the Southern Connecticut Gas Company to amend their rate schedules to the Public Utilities Regulatory Authority for entirely new rate proceedings, and ordered the authority to consider the underlying rate applications anew as if newly filed. On December 22nd, 2025, the authority issued a notice of procedural conference, which invited the company and all admitted parties and interveners to provide presentations regarding the procedures they believe should be followed during this proceeding. The purpose of today's procedural conference is to address the procedural requirements of the proceeding, including whether there is agreement among the parties regarding which evidence, if any, in the evidentiary record in docket number 23-1102 can be incorporated into the record of the instant docket. We have an agenda in front of us today. We will start with a presentation from the company. Following the company's presentation, we have time set aside for comments and questions. Before we begin, I will take appearances from any attorneys representing an admitted party or intervener. Let's proceed clockwise. But we'll take the companies first and then go around the room.
Good morning, Commissioners Smith, Cheeseman, and Beecher. Brendan Vaughn of Keegan Worrell and LLP on behalf of Connecticut Natural Gas Corporation and the Southern Connecticut Gas Company. I'm joined by David Martin, General Counsel for UIL Holdings Corporation.
All right, and
Mr. Hurwitz and Ms. Prescott are not counsel. They
okay.
will be presenting for the company.
All right.
Time.
Thank you. Thank you for correcting me. Office of Consumer Counsel.
Thank you. Good morning, Commissioners, and welcome, Commissioner Smith. Good to see you on the bench. Andrew Minikowski, Legal Director for the Office of Consumer Counsel. I'm joined by my co-counsel, Attorney Allison McCorney, and Consumer Counsel Claire Coleman. Thank you.
All right. Attorney General. Oh, sorry. You're next.
No, thank you, Commissioners. John Wright on behalf of the Attorney General.
And EOE from Pura, please.
Brittany Wyman, joined by my colleague Jamie Spanhake for EOE. Thank you.
Deep.
Good morning. Susanna Nigro on behalf of the Department of Energy and Environmental Protection.
Thank you. Have I left anyone out? Oh.
Hi, good morning. Shannon Lawn on behalf of Conservation Law Foundation and intervener.
All right. Thank you. That everybody, last call. All right. Now, if the company could give us its presentation, please.
Absolutely. And before I ask the panelists to introduce themselves, I would just note that I know that there are two separate procedural conferences scheduled for today back to back. We've prepared one presentation, and I assume much of the dialogue will be the same. So, in the underlying docket, we had two separate transcripts, and we addressed that through way of incorporation, asking a series of simple questions on the second docket to the extent if answers would be the same or if things would be presented differently. I just wanted to tee up that our presentation would not be different if there were a way to incorporate things by reference.
All right, well, when we enter the second procedural conference, we will touch on that so we can avoid duplication if necessary.
Thank you very much.
All right, thank you. If you want to proceed.
To start with introductions, I'm Jacob Hurwitz, Senior Director of Revenue Requirements here on behalf of CNG and SCG. I'm joined by my colleague, Ms. Prescott.
Hi, I'm Christy Prescott. I'm the Vice President of Regulatory for UIL.
Thank you all for the opportunity to be here today. We appreciate it. And Commissioner Smith, nice to see you on the bench. I don't know that this presentation will take the 25 minutes that we were allotted, but we'll run through it. I don't know if there's any way we could jump to the first substantive slide. Thank you. We presented a lot of this information in a motion. It's summarized again here, but in short, what we're seeking is an efficient and timely resolution of this matter. To that end, absolutely, my apologies, and it is, but I'm a very quiet talker. And please don't hesitate to remind me if I get quiet again. So as I was saying, we're seeking an efficient and timely resolution of this matter. And to that end, we are seeking 5 categories of steps that are outlined in our motion and summarized here. Number 1 is we are seeking a scheduling conference that is to lay out the key dates for some of these subsequent steps. Number 2, a statement of issues, and our vision is the companies would submit a statement accompanied by pertinent record information and context regarding the 7 key issues that we've identified. This would be comparable to the statement of issues in the UI motion for reconsideration proceeding. It's a different proceeding from this one, but an analog to consider. Then step number 3, other parties would be afforded an opportunity to respond. As much as we would like everyone to simply agree with the things that we say, we aren't sure that's going to happen. So in the event other parties disagree with our statement of issues, our step number 3 is to give them an opportunity to respond to what we put forth. Step number 4 would be technical meetings and or hearings about the information that was presented. And I'll note that this 4th step labels this as technical meetings - hearings in the same vein as what was said in our motion. I know there was a lot of discussion about the difference between a technical hearing and a technical meeting and a hearing in the UI motion for reconsideration. We've included both terms here just to show what an openness to either. Our final step is a staggered briefing schedule where interveners would submit briefs. There would be rounds of back and forth, draft decision, written exceptions to that draft decision, and then ultimately culminating in a final decision. And again, these 5 steps are designed to produce an efficient and timely resolution of this matter, give other parties an opportunity to respond to the company's statement of issues, and build upon the large body of evidence that was presented in the underlying procedural docket. And I'll note also that I understand this meeting today is happening in new docket 2025 docket, and the SCG meeting to follow shortly after this is occurring in another docket. The record information that we presented was on the record in 23-11-02, and we do feel that that is the appropriate venue for these remand proceeding to occur. If we could please jump to the next slide. Thank you. So as this slide lays out, the record evidence in the underlying docket number 23-11-02 is extensive. Evidence from the companies include direct and or rebuttal testimony from 14 different panels between CNG and SCG, hundreds of standard filing requirements that were filed once with the initial filing of the case, and then in many instances, again, in updated form in our case update in Connecticut that's known as late file 1. And because we had 2 companies, the LFE1 covered the updated cost of service for CNG, LFE 211 covered the updated cost of service for SCG, and that updated cost of service included a resubmission of many of these standard filing requirements that impact the company's revenue requirement. The evidence in the underlying docket 23-11-02 also included thousands of data requests, over 2,400 data requests from various parties, including OCC, many elements of Pura staff, EOE, and other parties. It also included 211 late file exhibits that were sponsored by the company. In addition, there was in-person oral testimony across 12 days of hearings and 2 days of late file hearings. And in our view, we can only speak for the evidence presented by the companies. We can't speak to the evidence presented by OCC or EOE or any other party. But in our view, the evidence that we presented, we're comfortable with. And we think the evidence that we presented is a reasonable basis for decisions on remand, subject to the process that we've recommended in the motion and reiterated here today. If we could please jump to the next slide. Further, in our view, relitigating or filing anew would be an expensive and inefficient outcome to this motion for remand. And I'll take expensive and inefficient in two pieces, timeline being the first piece, cost being the second. Starting with timeline, for context, Avangrid has had the opportunity to file several rate cases in the last few years. We've filed 3. One is the 2022 UI rate case, second is the 2023 CNG and SCG rate cases, and third is the 2024 UI rate case. And just for context on the timeline that might come with filing a new outcome, we've summarized here the filing dates of each of those 3 rate cases. In the UI 2022 rate case, that was based on a calendar year 2021 test year. We filed September 9th, 2022, so 9 months after the test year ended. In the 2022 CNG and SCG rate case, we filed November 2023, so 10, almost 11 months after the test year. And in the 2024 UI rate case, based on a 2023 test year, we filed November 12th, 2024. So again, 10 to 11 months after the end of the historical test year. The reason for that gap is preparing rate cases is difficult. There's a lot of information that goes into it, a lot of testimony, a lot of evidence, and the standards that PURA has set in recent years have only grown more stringent. So the information that we are required to prepare, and in some cases penalized if we don't prepare it, takes time to get ready. And if we're required to file anew, there's no getting around that re-preparation process. Also, there's a 350-day statutory timeline for rate case consideration. So if you run out the clock for what filing anew would mean, we take a lot of 2026 to prepare a rate case based on a 2025 test year. 2024 is, already kind of old. We file, say, late Q3, Q4 of 2026. I'm not committing to these things, just hypothetically. Then the 350-day statutory timeline would push us out to Q4 2027. It's the earliest resolution we could see for filing anew. It would also be quite costly. In the case of CNG and SCG, we sought approximately $2.8 million in rate case expense per company. Of that, about $750,000 was the cost of consultants for interveners, and excluded from that figure is the over 23,000 hours of employee time devoted to the rate case internal CNG and SCG employees or employees of the service companies that were working on those rate cases. And there's a cost to that time as well. So for those reasons, the timeline and cost unfairness that relitigating or filing anew would entail, we feel that that's not the appropriate outcome here. It doesn't turn the page by any stretch. Rather, it means that we would take another 1 to 2 years and incur millions of dollars more cost relitigating the past. So in our view, that is not the ideal path forward. Please jump to the next slide. It appears to us that the positions put forth in our motion and that we've reiterated today are consistent with statements from the Attorney General's legal counsel, from the PURA's counsel, to the Superior Court. And I know we've put this quote here on the screen. I'll just take a moment to read it aloud for everyone's consideration. This is a quote from Attorney Philip Miller from the Attorney General's Finance Department representing PURA. This is a quote made to the Honorable Judge Matthew Budzik on November 12th, 2025. I know there's a little confusion about this new hearing. I just want to make it very clear, Your Honor, that the new hearing is whatever the plaintiffs want. If they want to start at a new rate application, they can. If they want, but that's costly and time consuming. Maybe they want to start with the current rate application, the current test year, but start right after that. So whatever they want, whatever process they want. What I think Attorney Hollander suggested last time is some type of procedural conference was merely to sort of figure out exactly where they want to begin on the proceeding, because we don't want to waste their time and money if it's not necessary. That's all I want to include. They can have as much processes, as much hearing, start from whatever step they're comfortable starting with, Your Honor. Just want to make that clear. And in our view, that is not inconsistent at all with what we've put forth here today. We think that starting a new rate case filing would be costly and inefficient. It would be time consuming, and we've put forth the process that we would like to see. If we could please jump to the last slide. I will end by highlighting that the issues that we've identified in our motion are intended to represent a targeted collection of material drivers. Those issues are cost of capital, think things like ROE, cost of debt. The companies both received credit rating downgrades following the issuances of the final decisions that were the result of a improper process. Depreciation rates are one of the primary drivers of that outcome. There were significant cuts to depreciation for both CNG and SCG, and that created cash flow challenges. That is in large part the reason why the companies receive credit rating downgrades. The approach to rate year capital additions also carries forth a change that came about under the Gillette leadership of PURA. This is not consistent with how PURA decided plant additions in the past, and has also created challenges for the company's financial and operational. Our fourth issue is recovery of the FCIC regulatory asset. This is a tax matter where in our view, commission order required the companies to give customers two benefits while the companies themselves received just one, which is unfair and creates negative financial consequences. Fifth is the SCG tax reform liability treatment and rate base. In the case of every other regulatory asset and liability, PURA treated them one way. They excluded them from rate base and imputed carrying costs separately. In the case of this one particular regulatory deferral, which just so happened to be the largest regulatory liability at either company, PURA left that in rate base to the detriment of the companies. Item number 6 is a variety of O&M expense adjustments, including legal expenses, including the legal expenses that we incurred litigating these proceedings before the court. And then finally is the removal of DIMP caps, which have created challenges for the company. So these issues are intended to span the major drivers of the company's financial performance that relate to disputed areas from the 2023 rate case, cost of capital, operating expenses, financial performance, et cetera, but are at the same time intended to be more targeted than a complete relitigation of the cases. We didn't want to, start anew, require everyone to incur and pass on to ratepayers the millions and millions of dollars that a full rate case would cost, the time that would take. We were trying to propose a efficient and targeted path that rights the wrongs of the past and sets the companies, their customers, up for success moving forward. So with that, stop there and see what's next.
So that concludes your presentation.
It does. Thank you.
Right. Any comments from the attorneys on this, or you would like to let that stand before we go further?
I think we're happy to respond to any questions
All
or
right.
comments that others may have, but not right now.
All right. Well, before we hear comments from the interveners and other parties on your presentation, I have several questions for all of you from the authority. I'm trying to determine whether there's any agreement amongst the parties regarding whether any evidence in docket number 231102 may be incorporated into the instant docket and therefore considered by the authority in rendering its decision. I would like to make it clear that the authority will issue a decision in this docket on the entirety of the company's rate amendment application. The decision will not be limited to only certain topics or issues. My first question is for the company. Based on your presentation, it is the company's position that the entirety of the evidentiary record in docket number 231102 should be incorporated into the instant docket and considered by the authority in rendering a decision, correct?
I can start or let council go first if they would prefer.
Well, I'm happy to have Jacob chime in. I think to the extent that question was directed to council, my response would be that our position is that the most efficient way to to conduct the remand would be through the underlying docket where the evidence already exists.
So the
231102.
we would admit everything contained in 231102 into this new instant docket. Is that correct?
If you were to conduct the remand in the two new dockets, I think that would be correct. We were saying for efficiency's sake that the correct place to do that was the existing 231102 docket. But if that's, I guess, and I guess I'll put it there.
So we have a new docket, for which this is the scheduling conference. The question is, do we move everything over from that prior docket and incorporate that in this new instant docket?
I think the answer is yes, based on the court's decision. It says that you've got to consider the underlying rate applications anew, right? And I think you quoted from that at the start of this hearing.
Okay, so we will include, and obviously we're going to hear from other parties, but it is your view that the entirety of the previous docket that has been remanded will be incorporated into this new instant docket.
Just a couple of comments. One, we can only speak for the information presented by the companies. We can't speak to the information presented by other parties. And also, just to address the first part of your question, I'm not aware of any type of agreement. I think what council was highlighting is our position is that 231102 is the appropriate venue for this reconsideration remand. I think if you are saying that, well, that ship is sailing, we're doing it in these new dockets, well, we can consider how we want to react to that. But I think if that is the decision, then yes, we would still be comfortable with the evidence that we presented originally in 231102. We're comfortable with the evidence we presented full stop, regardless of which docket it's presented in. But I think to reiterate, we are taking the position that 231102 is the appropriate docket for this.
All right, we'll take that under consideration. All right, moving on. So we will incorporate that docket into this new instant docket going forward. Yes.
I don't know that I'm prepared to agree to that, but I'm also not able to tell the authority what to do. That's beyond the scope of my ability, so.
All right. I think we've gone about as far on that as we can. Now, I would like to ask the interveners specific questions regarding the evidence in the record in docket 231102. So I'd like to start with the Office of Consumer Counsel. I think that's probably easier, if you could. All right.
Commissioner, I know you have specific questions, but if you'd allow, I'd love to briefly respond to the presentation that CNG, SCG provided and just give our perspective.
A general overview, yes, because and then I am going to go through very specific elements of that evidentiary record to find out where OCC stands as an intervener on those particular elements of the evidentiary record.
Great. I just wanted to ensure that the commission understands that from our perspective, despite the procedural and errors and irregularities found by the court in the CNG, SCG decision that was focused on the procedural aspects. They did not make any ruling on substantive issues. So we want to make sure that the commission's aware that we strongly disagree with the company's presentation of the 5 issues that they're seeking to pursue and have reevaluated. We believe that the substantive analysis of the company will stand, and the process set forth by the judge, which says, in our view, well, I guess I should step back. We also have a differing view of, I think, of what the judge was directing in the decision, and I'll let Attorney Minikowski go through the key provisions of the court order. But in terms of where we are right now and the considerations of the authority in terms of the timing of all of this, we don't see this as urgent. Obviously, the companies are entitled to a remand per the court's decision, but we don't believe that unjust and unreasonable rates are currently being charged, as has been framed by the company. In fact, their recent financial reports have shown they're doing well with, ROEs in the 8.2 and 8.38% range, notwithstanding these two decisions that came out as a result of the prior rate case. So we think it's important to adhere to the court's direction and ensure that, CNG and SCG get their fair opportunity for a remand, but also that, we're not setting this up in a way that just expedites a rate increase, which would
Understood.
negatively impact customers.
Understood, Commissioner Coleman. I think you've made your position clear. And in the interest of getting everybody's a chance to weigh in on what we want to proceed with today. And obviously, the authority will address this accordingly.
Right.
Taking your concerns into account. Now, if I may, I'd like to run through different elements of that prior docket to see how OCC stands in terms of incorporating them into this new instant docket.
Sure.
My first question regards the audit materials in the evidentiary record in docket 23-1102. Does OCC have a position on whether these materials can be refiled in the instant docket 23-1113?
So I think based on the court decision says that rather than making a decision based on a record compiled in an unfair hearing proceeding, the far better course is to remand this matter as set forth herein, such that any decision on the merits of a final rate decision can be based on a record that was compiled fairly. Now, the companies have, I believe, conceded that the record was compiled fairly. At this point, their motion says that the evidentiary record is sufficient to serve as a basis for decision on remand, subject to the process recommended by the companies. I think our concern is, whether or not this complies with the court order. And I think you specifically asked about audit
Yes.
record. So, it's hard to, so the other piece of this, and I'm sorry not to give you a direct answer, is that I'm also understanding the company's request to say, we're going to move the entire record from the prior rate case into the new, whether it's 23-1102 or it's the new 25 docket. But then we're also going to add some new evidence. I believe they requested the addition of rate base updates and legal expense updates. So I think to us, it's that's not a remand of the prior decision. That's a new case. So it feels like we're trying to live in both worlds. So our answer as to specific evidence might depend on the authority's decision to, whether it allows extraneous evidence or not. If it allows for new evidence, then we're going to need the ability to rebut that with our own new evidence. If it's just confining to the 23-1102 evidence without any new evidence. And we're actually doing a remand of the prior, rate case, which I understand, procedurally is tricky with how test years work, but nonetheless, that's what the judge ordered. We might respond
So
differently.
the answer is maybe.
Right. I know.
Okay.
You want to clarify?
No, I mean, I think it's just, we're in a tough situation here because the judge essentially said reconsider this from the application. And so we're stuck. I mean, to the extent the authority issues a new decision and someone's unhappy with it, it would be extraordinarily easy to challenge if that decision in some way did not fully comply with this court order.
Okay. Okay. I just, would the company care to comment?
Sure. So just to back up briefly, there were a few things that Consumer Counsel Coleman said that I just don't know if I think what we've asserted, as Mr. Hurwitz said, is that the evidence that the company put forward can stand as the basis for a decision. The company's comfortable with its evidence as part of that record that it can speak to, and others can speak to their own evidence. Secondly, I don't know if the company conceded that refiling everything was appropriate. I think what Mr. Hurwitz said was that our position, as reflected in the motion, was that the best venue for this was 23-1102, and that if that was not going to happen, then yes, that the record of 23-1102 should be moved over, but just it wasn't the company's position on that. And to respond briefly to Consumer Counsel Coleman's point about not seeing this as urgent, I entirely disagree. I mean, the company had a right to a legal decision and to just and reasonable rates from the rate case that it filed in November of 2023. It did not get that. It did not get a legal decision. It did not end up with just and reasonable rates. And the substance of the issues were not addressed because the judge was uncomfortable being deferential to Pura in an instance where the process had been so fundamentally tainted. So we're in a little bit of uncharted territory here, right? Where everything was kicked back because of this, but we had that right to a lawful decision. We didn't get it. Our rates now have been, for the past year, not reflective of our cost of service and unjust and unreasonable in our view. And we're asking you to correct that by evaluating these main drivers as highlighted by Mr. Hurwitz. These are the drivers that we highlighted in the draft decision, or in written exceptions to the draft decision, and in our appeal. They're the main drivers that drove a downgrade. And the quote that Mr. Hurwitz read from that hearing, where I believe Attorney Minikowski was at that hearing, and I don't want to rehash it, but that had to do with the judge's concern over enforceability of the request by Pura to remand this case back to Pura. And Pura's counsel, through the Attorney General, made several statements to the court about how that would look and what that would look like, and that it would look like what the plaintiffs, the companies, wanted it to look like, and that's where we are. So we do feel that any other answer, filing new rate schedules, starting over from square one, is penalizing the company for things that it did not do, and for the actions of other parties that deprived the company of its right to a lawful order, and that we would have to look at our options on what we would do, and if we needed to go back to Judge Budzig on that, we would have to evaluate that. So that's just a quick rebuttal.
Thank you. All right. Next on my list, my next question regards the interrogatories issued by the authority in docket 23-1102. Does OCC have any objection to the duly designated panel in the instant docket adopting those interrogatories issued by the authority in docket 23-1102?
I think if the authority is choosing to pursue the route of integrating evidence and relying on it, we have no specific concerns with the interrogatories.
All right. This relates to non-Pura interrogatories. You would have no objection to incorporating those non-Pura interrogatories issued by non-company parties and interveners into the record of the instant docket.
Everyone I can see that. We would be comfortable stipulating that, you know, the full record of evidence under 2311, 1202, sorry, 231102 is appropriate to incorporate into the remand so that we're not repeating work. I agree with the efficiency, but I'm just a little hesitant to state it in a way that fully concedes our
Sure.
legal
I just,
rights.
what we're trying to determine today, if there's any agreement among all the parties as to what evidence in that docket 231102 we will be incorporating in the new docket. We're not making any decisions today. We just want to get the pulse of the parties in terms of what that's contained in 231102 we will be moving into this instant docket.
Thank you. So with that clarification, we don't have any objection to any specific evidence being relied on. I think we just want to reiterate our concern about the consistency with the court ruling.
Okay, my next questions regard the motions filed in 231102. And the first deals with motions for party status and interveners. Do you have a position regarding whether Pura should refile motions for party status and intervention filed in docket 231102 and their rulings in the instant docket? Or should we require the entities to resubmit their motions in the instant docket? I.e., do we just carry over the motions and admit parties and interveners based on that 231102, or should we have everybody resubmit?
Guess I'm reluctant to speak for the interveners. I don't know if the
I'm
interveners
asking,
that
sorry, Pura
participated-
specifically.
Right, assuming the interveners that participated in the underlying docket are intending to participate in the remand, we would see no need to repeat the
All right.
motion practice.
All right, thank you. Now this deals with motion for protective orders. Again, can we refile those motions for protective orders that were contained in 231102 and the rulings in the instant docket? Or should we require the company to resubmit their motions for protective orders in the instant docket?
That's a harder one because it's a procedure, is somewhat connected with the procedural aspect of the case, which was obviously the focus of the judge's remand. And I don't think we know off the top of our head what those specific motions for protective order were. It seems the safest course to have for the authority to consider anew any procedural motions given the court decision.
Does the company, I,
But I guess if, then the caveat is if it's related to interrogatories or, discovery, I'm not sure we have a concern or need to relitigate the authority's rulings on what discovery has a protective order, but I'm not sure if there are other bigger protective order motions at issue at this point. Do you recall? Oh. Yeah.
so this is probably not, but possibly? And it did.
Well,
Attorney
I
Vaughn, did you
think-
have a
I think the line of questioning highlights and supports the company's proposal is what I would say, is that there's a lot of complex issues that are being raised by you in this, as far as when, if we move everything over, what do we do with the motion rulings? What do we do with, the rulings that were signed by the executive secretary, which I understand is not intended to be this commission's practice any longer, but we all know from the appeal is not supported by law. There were some protective order rulings that I know off the top of my head were denied or denied based on, changed circumstances, things that had been protected historically that were, not protected any longer, but that information's now been filed and the cat's kind of out of the bag on that. So I don't know. I do think it highlights, questions about why I think it supports why what we've proposed makes the most sense is that we're talking about, a smaller scope on a more limited number of issues with fresh eyes that maybe avoid some of those thorny questions. There's I know you asked about interrogatories and questions about motions. The company issued interrogatories to EOE that were struck through an executive secretary letter ruling. So I think that, there are things like that that come up in the underlying, if we are not adopting the company's proposal. So I think that what we've proposed is sort of in the interest of fairness and administrative efficiency. And I think that some of these questions support that.
Okay, well, as I reiterate that this is an information gathering session. No decisions are going to be made. We may seek further information from company and parties and interveners. The goal is to create a process through which we get the appropriate decision with new eyes. So that is the plan. And to a certain extent, we're all winging this. All right. Other motions. Do you have a position regarding the incorporation of any of the other motions that existed in that prior docket in the new instant docket?
I apologize. We'd need to review those motions and, in order to determine, it does seem like, if you're within the context of the remand, considering the evidence anew may require, the point of that is to allow the company process. So, I'm, assuming motion rulings would come out the same way. I'm not sure if I would agree with that, but I don't know that we have any particular concerns with any specific motions or
Right.
motion
Okay.
rulings.
So
at this
again,
point.
Possibly,
Yeah, sorry.
as I say, we're gathering the information. We will be using it as we formulate this process going forward and ideally come up with something that is not going to make everyone happy, but is going to make people equally unhappy. Let's put it that way. All right. I think that's it for OCC with regard to the elements of the prior docket. Any further comments from you? Commissioner Coleman?
Thank you, commissioners. I appreciate this process, and I also appreciate the company's proposal as a way to potentially move forward. I just want to stress in closing that we have a court order. We're very limited. I mean, I recognize the company wants to move forward. No one wants to redo entire rate cases. It's extremely burdensome, as Mr. Hurwitz laid out this morning. But we do need to make sure that whatever the authority does, we are in compliance with this court order. I thank the company for their presentation, but I think everyone speaking of being equally unhappy was equally unhappy with elements of this decision, but unfortunately, that's the
All right.
world we're living in.
And I apologize. I neglected to ask about two further elements of the existing docket. Do you have a position regarding the pre-filed testimony? Can we refile in the instant docket the testimony filed by non-company parties and interveners, rebuttal testimony filed by the company, and surrebuttal testimony that existed in that prior docket in the new instant docket?
We have no concern with that. We read the, Pura must consider the underlying rate application anew as if newly filed to be, or reconsidering, or, the authority is considering through remand that evidence.
Okay. And I have the same question regarding the hearing transcripts. Hearing transcripts from 23-1102 be incorporated into the record of this new instant docket.
Same answer applies.
Okay, and this with regard to the late filed exhibits, again, take the late filed exhibits from 23-1102 and incorporate them into the record of this new instant docket.
No specific objections there either, and I think all of our answers, have the same caveat that, we read this decision as assuming that because of the arguments that the company made, that they'd want to start completely anew and wouldn't want to rely on evidence, but as we're hearing, the company is okay relying on that old evidence, and that's why we're sort of in this gray area where we're all wanting to do something efficient, but it's not seeming to be consistent with what the court was envisioning.
Well, we'll find out, won't we? All right. I think that's it for OCC. Does the company have a quick comment?
Yeah, I guess the point that I would make is that I disagree with the inconsistency. You know, I think what we've proposed is entirely consistent with the assertions made to the court and that were made to assuage the court's concerns about enforceability of the remand process. And I think that the application of the company is, what was filed, in November of 2023, but I would say that the entire application is updated and amended throughout the case, and the application, the final revenue requirement is also the application. I think that doesn't necessarily mean you have to go back to the pre-filed testimony that we submitted on November 12th. I mean, I think that what we proposed is not inconsistent with the court's order.
All right, and comment, and then there was something I'm
Sure,
going to move
thank you.
ahead while I have you seated here, Office of Consumer Counsel.
Sure, I think those remarks triggered one of our concerns about the company's proposal, which seems to be a hybrid. A remand is a redo of the same case, right? So in this case, it would be the 2022 test year and the evidence that was produced throughout the hearing around that. But I do want to flag that even the arguments I'm hearing Attorney Vaughn make seem to be inconsistent with that secondary request to add new evidence, which is updated, rate base and legal expense numbers. It seems to be trying to have it both ways.
That's something we're obviously not going to decide here today. We will take that under advisement. And before you go, I have a couple of questions I'd like to pose to the company and then pose to you, so we're not going back and forth. My next questions, which I'm going to pose to you first as the representing the company. Do you have a position on whether Chairman Wheel should recuse himself from the instant docket?
So what I can do is, I haven't flagged too, but Attorney Martin has this. So I do believe that the composition of the panel was discussed before Judge Budzik at the evidentiary hearing, or at the hearing on the motion for the second motion for remand in the appeal. And again, it's just an Attorney General Miller saying, in this case, Chairman Wheel and Commissioner Arconti have to be recused. So we have 3 commissioners on the panel. So it would be Commissioner Cheeseman, Commissioner Beecher, and Commissioner Karen. I'm told that Commissioner Karen leaves at the end of the year and that he'll be replaced by Commissioner Smith. So you'll have a 3-person panel under 16-2C. So again, that's pure as counsel saying what their view was for the composition of the panel.
Okay,
On
well,
remand.
that was pure as counsel.
Yeah.
I'm asking you, the company, do you have a position?
I guess what I would say in speaking with Mr. Martin is that I understand that, Chairman Wheel has already recused himself from the underlying case, and that the record that we're discussing is really based on the underlying case, so that recusal would likely be appropriate. Similarly, Vice Chairman Arconti, I believe, was working at Avangrid during the preparation and litigation of the underlying case, and has already recused himself, I believe, in 23-1102. And I think that would hold, that logic holds for if we move forward in these new cases based on those old cases where the chairman and vice chairman had substantial participation.
All right. And my last question to you before I pose these questions to the Office of Consumer Counsel. Do you have a position regarding whether there is a statutory deadline relating to a decision in this new instant docket and remand?
Yeah, I think I hate to sound like a lawyer, but I think it would depend on, what comes of this, right? Again, as we said, if we're ordered to file a new application or that, if the order that comes out of this is moving over the initial application from 23-1102 and then saying we're relitigating it as of such and such a date, as I said, we would evaluate our rights with respect to such a decision. And the consistency of that and what we would have to do at the Superior Court level. But I think that the answer to that would depend on what comes out of your decision, unfortunately. So I don't have a solid answer on that for you.
So TBD.
Yes, and again, I think that cuts towards what the company has proposed, which is, establishing a scheduling conference as an initial step where we could talk about, setting out a reasonable path that could right set the company's rates and correct and give the companies a lawful order, in a fair amount of time.
Okay. Back to Office of Consumer Counsel. First question, do you have a position on whether or not Chairman Whale should recuse himself from this new instant docket?
Sure. Thank you, Commissioner. Just to echo Attorney Vaughn's comments, I believe the chairman and the vice chairman did recuse themselves in the underlying docket. I mean, I think that's just a decision that Chairman Wheel and the vice chairman would have to make with their counsel.
But we would have no objection. We would not oppose their participation in the new docket if they examined it and determined that was appropriate.
All right. And finally, do you have an opinion as to a deadline for the conclusion of this?
Yes, thank you. So that's a tougher question. Presumably there is one because there's one by statute. I mean, if I had to guess, it would be the date the remand order was issued is when the clock started to rerun. However, I would just like to float to the extent the commission and the company and the other parties have outstanding questions about how this needs to work under practice book 66-5. The parties to the appeal could pursue a motion for articulation to have Judge Budzik clarify his ruling in any way to ensure that we all are operating within what he envisioned, including timing or any other issues that may still be outstanding. Just something to explore and consider for all the parties.
Okay. I think that exhausts the questions I have for you. Any final thoughts before I bring up Office of the Attorney General?
No, thank you for working through all these very weedy, tricky issues.
It's a great way to start the new year,
I
isn't
was
it?
going to say, Commissioner Smith, welcome aboard.
All right. Thank you.
Thank you.
If the Office of Attorney General would like to come up here and now you had a preview, so you should be prepared. Yeah. You make sure your mic is on.
I think that works. Oh,
Yeah.
perfect. Yes, thank you. I'd like to say I was prepared, but we're all in sort of new territory with this. I don't recall a rate case coming back under circumstances like this, and I think it's difficult to make all the kinds of determinations that you're seeking to make here today. So
We're just doing the best we can, and, all right. So I will pose the same questions to you that I posed to
Absolutely.
the Office of Consumer Counsel. First, to do with audit materials. Do you have a position on whether we can include those audit materials filed in original 231102 in this new instant docket?
our office will not interpose any objection onto that. I understand where you're doing. I think this is a very difficult position to be in because it's now 2026. The application was filed with a rate year of 2022. And it's very difficult to sort of take a look at what the facts and circumstances at the time when this original rate case was filed and to translate it. There's going to be something that's missing. And that will, and for parties that are unhappy with the decisions that you make on incorporating certain types of evidence, it can be an appealable issue. And that's not to point fingers at the company. They have to protect their rights. They're concerned. And our office is similarly concerned about the expense of resources and money and time to pursue a case. But any other course also presents these vulnerabilities that you're going to do. So navigating that path, we'll try and stay out of your way on that. And that would be the best answer I think I could give you on that. We'll not interpose any objections to how you treat audits. Interveners, we're happy to file motions to intervene again or to be there. Interrogatory responses. I think as long as there's an opportunity to question the witnesses on those, we'd be okay with that as well.
All right, so both pure interrogatories and company and non-pure interrogatories could be incorporated, moved over from that 231102 into the new instant docket.
We would not object to that.
Motions. Should we, again, carry those over, or should we require entities to resubmit part motions for party status and intervention?
I'm not an expert on procedure, and I don't want to give you advice on how to do something. The court has found that there were irregularities in the decision-making process, and that cast suspicion on the judgment of the rulings. These were not rulings that concerned us, but they did concern the company. So I'm a little less.
Relating to the signature by only the executive secretary as opposed to a full panel of commissioners?
If you were to revisit all of those decisions by a full panel?
No, but you as the Attorney General's office, as far as you can tell me and this panel today, would accept motions filed for intervener status that we would carry over into this new instant docket?
Yes.
Okay. Protective orders, again, would you accept that motions that were granted for protective orders could be carried over into this new instant docket? Or would company have to resubmit?
I think they could be accepted as long as the parties had an opportunity to flag any objections that they had to that.
Any other motions? Again, carry over into this or require resubmission?
I can't give you the full spectrum of motions. I simply don't recall. I think that might be on a case-by-case basis, and
So it
perhaps, yes.
Pre-filed testimony. Again, carry over from the original docket.
I don't have an objection towards that. We would not interpose an objection, but it would be limited to the time frame that it was provided, and that information would be somewhat dated, and it would have to be accounted for during the hearing process. But yes,
And same question with regard to hearing transcripts and late filed exhibits.
yes.
Recusal. Does the Attorney General's office have an opinion as to whether or not Chairman Wheel should recuse himself from this new instant docket?
We take no position on that.
And Vice Chairman Arconti?
We have not taken a position on that, and I understand both commissioners have recused themselves. I do not find that inappropriate. We've just simply don't take a position on that.
All right. And finally, do you have an opinion as to the statutory deadline by which we should issue, this authority should issue a decision?
I think the Consumer Council explained the difficulties that might be, that might arise. You wouldn't want too short a time frame. In particular, I think it can be difficult to ask the Superior Court for guidance on some of these issues. And I can't give you an answer on that, but I will echo the comments of the Consumer Council that if the deadline were reasonable and if it were from the date of the remand, that would be acceptable to us.
All right. Any further comments that you would like to make? All right.
Thank you.
Thank you. All right. Pura's EOE, please. Education, outreach, and enforcement. Good morning.
Morning.
Good morning.
Just for the record, I'm Attorney Brittany Wyman, joined by Attorney Jamie Spanik for EOE.
Do you have any opening comments?
Well, if I may, I'd like to answer most of your questions, or at least a good part of your questions at once, just for some efficiency. I'd like to reiterate first what OCC Consumer Council was stating. The remand decision from the Superior Court specifically states that the application should be remanded as if newly filed. And that is EOE's position, as we stated in our objection to the company's motions in all three of the CNG and SCG dockets. I think a lot of the issues that we've been discussing here today are why it needs to be newly filed. A lot of your questions, Commissioner, have been, well, what evidence, what motions, and I think more importantly, motion rulings would be allowed to transfer to these new dockets versus this previous docket. And although EOE believes that this needs to be start anew from an application, so all of that should get redone, it is sort of an all or nothing issue. If the company's evidence would be allowed, which I believe is what the company it said in their motion, they accept that their evidence is sufficient, all evidence should be allowed. The motion rulings is a new panel. EOE would have questions if those motion rulings would need to be reissued under the new panel, or if those would be acceptable by stipulation to move over. And one of the issues that Attorney Vaughn did bring up was the one where EOE was involved. We objected to interrogatories asked specifically to us. It was ruled in our favor, that objection. I believe it's one of the items that the company believes was biased. And now we may disagree with that characterization. It is yet another example as to why everything needs to be redone and why we believe the Superior Court said this needs to be a brand new docket, a brand new application, as if none of the other work had been done. And the quote that the company has brought up a few times that the AG stated about the different issues, and that it could be costly and we're not trying to waste time. That was said on November 12th in the hearing. The court order or the court decision was on November 19th. Judge Budzik heard that information, heard that argument, which is an argument from Pura's counsel, and arrived to a different decision that the application should be anew. So in EOE's opinion, either we're using that same application and we're just starting all over in these new dockets, or they can file a new application. And in either option, I don't think EOE would object to either Chairman Wheel or Commissioner Conti being on the panel. And I believe I did miss some of your questions, but I hope I got most of them.
So in your view, it either all moves, you don't have an objection to Commissioner Wheel or Commissioner Conti being seated. And do you have an opinion as to a statutory deadline?
So if we are to look at what EOE believes, so a brand new application, as all parties before us have stated, this is a new situation, and clarity may be something that needs to be sought. But if we are starting this application anew, it would be the time the application is refiled, the regular statutory deadline would be sufficient or appropriate.
So just to be clear, with regard to my questions, specific materials, audit materials, interrogatories, non-peer interrogatories, late filed exhibits, it can all go in your, if we are moving to incorporate all of that from the 231102 into this new instant docket, you would not object to taking the whole ball of wax?
So as I stated, EOE does believe that rate case application needs to begin anew, so none of it should move. However, should the authority decide that it is more efficient and appropriate, it should be everything that moves, not just a subsection.
Okay. I think that's clear.
Thank you.
All right. Any other?
Our one question would be about if everything moved, the motion rulings, because again, the motion rulings were a portion of the company's appeal stating that the executive secretary signature wasn't sufficient, and that the decisions were made biased, which was a portion of what was in the remand decision.
So that's what you mean by a subsection of?
Right. And so I'm uncertain of the legal authority or if all motion rulings are appropriate to be moved over or not because it is a new panel.
All right. So, but just to be clear, so absent the question of motion rulings, everything else contained in 231102, should the authority choose to move that entire record over into the instant docket, everything apart from motion rulings you would accept to be incorporated into the new instant docket from the original 231102?
Yes. Yeah.
Okay. I think that's it.
I don't know if I missed any of your.
I think it was audit materials.
Yep.
Pura and non-pure interrogatories, the motion rulings, which we've touched on, late filed exhibits, check my cheat sheet. Pre-filed testimony,
Yes, all of that.
recusal.
In recusal,
Okay.
either if the application began anew, either with the previously filed application or if the company chose to update it to be current since it was 2021. I think in either way, we would not object to either Chairman Wheels or Commissioner Conti's or Vice Chairman Conti's participation in those.
And statutory deadline,
Application date.
original,
I would say, since this is a brand new rate case, it should be from whatever that application date is considered, whether it be the time from the remand decision or the newly filed version from the company.
Okay,
Thank you.
thank you. Deep. Please. Department of Energy and Environmental Protection.
Commissioner Cheeseman,
Oh,
while Deep comes up to get situated and respond to your
Yeah.
questions, I'll just note if at the close, if we could have some sort of opportunity to
Yes,
just conclude,
absolutely.
I would appreciate
Yeah.
that. Thank you very much.
I want to make sure everyone feels that they have left this proceeding with the chance to appropriately express their feelings, and we will take everything into account when we render a decision. Good morning.
Morning. Thank you for this opportunity to discuss this. Our position, I don't think, differs much from the council that have gone before. I think that's the advantage of being at the end of the line. So to try to, summarize it with respect to the audit and interveners and in pre-filed testimony, I don't believe that there would be an objection. With respect to the motions, protective orders, and potentially interrogatories, I think we would generally align our position with what OCC has previously stated.
So basically, it would depend.
Yes.
You could not necessarily accept all of it. Yeah.
It's really broad questions, and sometimes it's hard to give specific answers to, a broad swath of information. I don't have a position on the statutory deadline. Don't believe that we would file any objection with respect to recusal.
And pre-filed testimony, late filed hearing record, and late filed exhibits.
Generally, I don't believe we'd have an objection to that.
All right. Well, you made this very brief for me.
I hope I
Do
covered.
you have any further comments you would like to make?
No, nothing in addition to what's already been said. Thank you.
Yes. Yes. All right. Thank you. Conservation Law Foundation, please.
Yes, thank you, Commissioner. I hopefully can make this even shorter for you because I believe we would take a position consistent with what we've heard from EOE, the Office of Consumer Counsel, and DEEP. If you'd like to go over any of the specific questions, I'm happy
right.
to answer those.
Incorporation of the existing audit materials from 23-1102 into the new instant docket.
I think similarly, our reading of the court's decision is that if we are going to incorporate the record from the underlying docket, that everything should be incorporated, and we would not have any objection to the audit materials or other.
And non-pure interrogatories.
Yes, no objections there.
Okay. With regard to motions, I know there have been concerns raised about some of the motions from some of the interveners.
Yes, depending on how the authority would like to handle that, I think it would likely be appropriate to give the parties and interveners an opportunity to make an objection to those motions, given the concerns that the companies had raised in the litigation, but would defer to the authority on how you'd like to handle that.
And pre-filed testimony, hearing transcripts, and late filed exhibits incorporating 23-1102 into a new instant docket.
Yes, no objections there.
All right. Do you have a position on recusals of Chairman Wheel or Vice Chairman Arconti?
Similarly, we would defer to their judgment as to whether to recuse themselves as they've done in the underlying docket. I think we would not object should they choose to participate as members of the panel.
And do you have a position on a statutory deadline?
I have not researched this. My expectation would have been that it would be told from the date of the filing of the application, but I don't feel I can opine on that.
All right. Do you have any further comments you'd like to add?
I don't think so, other than thank you for taking the time to get everyone's opinions and working through all these very challenging procedural issues.
All right, thank you. Before we allow the company to weigh in again, I'm going to take a 15-minute break so we can consult as a commission, and we will, what is the time? Return again at 11:30. So we stand in recess. All right, we will reconvene this procedural meeting. Before I allow the company to make some closing comments, I believe Commissioner Beecher has a question for Attorney Minikowski, if he would like to come up, please.
Thank you, Attorney Minikowski.
At your service.
I got, thanks. I got a sense you and I were thinking about the same question. So I appreciated the opening presentation, and we have a quote there from Attorney Miller. But then we have, as you said, a week later, you and I highlighted the same, I think the same thing. And the order is pretty clear. It does not quote Attorney Miller in that case. It says, pursuant to the court's authority, Bureau must consider the underlying rate application anew as if newly filed. So Bureau wants to comply with the judge across the street. And that's our priority. So I got a sense that you had done some thinking about this too and some analysis. And so at the beginning you said, you might give a summary. And so I was just going to invite you back to share your thoughts about how we comply with the judge's order.
Sure, I can weigh in on that. Thank you, Commissioner Beecher. Yeah, I mean, obviously, as Attorney Vaughn mentioned, I was familiar with the arguments made by counsel before Judge Budzik, since I was in the room, as much as I'd like to forget it. And I mean, the judge was interested in this. He did want to know what was going to happen if it did get remanded pursuant to Pura's motion. And, Attorney Miller offered what he offered, and had the judge wanted to enshrine that, he very easily could have by laying that out in his order. However, he went further. I mean, he said, consider the application anew, as if newly filed. And so that's a tall order, but it was within the judge's discretion to make that decision as part of his remand order. And even when, the companies had wanted the judge to go further and make a ruling on the merits of their actual claims, and the judge declined to do so on the basis of his remand order, which concluded that, the underlying record was tainted by these procedural irregularities. And so the court itself was not comfortable relying on the record that was established in the proceedings below. Now, I know we've all discussed here this morning that many of the parties are comfortable with portions or some portion of the record and potentially stipulating to reusing that. However, my lingering concern, and Consumer Counsel Coleman made this caveat when we were speaking before, was even if we all stipulate, hey, the record or this part of the record or whatever is fine, will that be fine to Judge Budzik if he requests a status update or requests the filing of the remanded decision, or if some party takes an appeal of the new decision on that basis? And that's the open question here, given the sort of the extraordinary breadth of the remand order that the judge issued.
And so what about the practice book section regarding a motion for articulation?
Yeah, so it doesn't usually happen in administrative appeals. This usually happens in the higher appellate context, the appellate or Supreme Court, and there's a question of what did the trial court mean when it ruled X, Y, or Z. We're sort of in a slightly adjacent procedural stance here because we're in an administrative appeal where Pura was the initial finder of fact and decision maker. But I believe we could, or any party that was a party to that appeal, including Pura, could file a motion for articulation through counsel asking the judge to clarify or articulate his order. And that would be a way to ensure that whatever process Pura elects to follow in the remanded proceeding comports with the judge's understanding. That way, there's just no ambiguity. The parties, Pura, everyone will know exactly what it was Judge Budzik had anticipated. I mean, obviously, there's a lot in this court decision that is unrelated to this narrow scope of what is the remand order. So again, that is one avenue to potentially clarify this. And again, any party that was party to the litigation has the opportunity to approach the court and request that. And just based on my experience in court, I would say a judge would prefer to receive a motion like that rather than receive another administrative appeal a year from now of the same decision. Because I just have the feeling the court would not be amused to see this return in that form.
Thank you so much. That's very helpful. Consumer Counsel Coleman, do you have anything to add or you?
Nope, he stated that well. Thank you.
All right, super. Any others in the room? Should we ask if they would, before we get to the company, as far as other parties or interveners, I think we're okay. Okay. Thank you so much.
Thank you.
Thank you. And now, Attorney Vaughn, you have the floor.
Thank you very much, commissioners. I will be passing the microphone to Mr. Hurwitz to provide the company's concluding remarks.
I just wanted to thank Pira and the new commissioners again for the opportunity to be here today. And I think Commissioner Cheeseman, you expressed it as I'm going to give everyone a chance to express their feelings. And I have so many feelings to express. So just thank you for the opportunity. We filed the underlying rate cases in question here in November of 2023, and that entitled us to a decision in 2024. We, as the companies, spent millions of dollars, tens of thousands of hours, dozens of days at hearing, defending the application that we presented, supporting every element of what we requested, and we held up our end of the bargain. Requiring us to prepare an application anew would be an incredibly unfair outcome. It would be unfair both in terms of money and in time. I think we heard from the OCC and the EOE today differing perspectives on what the statutory deadline for refiling would be. My notes have the OCC suggesting that the deadline would be in the range of Q4 2026 because the clock starts with the court's remand. My notes of what the EOE represented would have the outcome here in Q4 2027, almost 2 years from now, because the clock would start with whenever we refile a new case. And to suggest that we could file a lawful case in November of 2023 and then not get a legal resolution until 4 years later, just as a non-lawyer, strikes me as tremendously unfair, illogical, and the company would likely have to explore its legal options in the face of that outcome. In terms of money, we incurred millions of dollars of rate case expenses litigating those proceedings. Both CNG and SCG had their credit ratings downgraded as a result of the outcome of that proceeding. We lost the opportunity to invest what we otherwise would have because the final decision in 23-1102 did not fund any forward-looking capital, a break from decades of prior PIRA practice. OCC themselves represented today that our ROEs were strong, and they quoted ROEs in the range of 8.2 to 8.3, which is almost 100 basis points below our authorized ROE. And this isn't just in the company's interest, it's in customers' interest too. I think as a just basic matter, customers benefit from just and reasonable rates, and I don't know that they have them today. Customers benefit from cheaper debt, and credit rating downgrades make our debt more expensive, all else equal. Customers benefit when the companies take advantage of the constructive elements of the tax code, like tax basis repairs, and the outcome of 23-1102 has challenged the company's ability to do that. It's one of the 7 items on our list. Customers benefit when the companies invest capital at the appropriate time, and the financial challenges imposed upon the companies by the outcome of that case has challenge our capital spending. It seems that the direction of the questions and discussion that we've heard today are pointing in the direction of a new case. That would be a disappointing outcome to us. It's not what PIRA's lawyer said would happen, and we would have to evaluate our legal options in the face of that outcome. We filed a lawful case. We tried to identify these issues on the record for PIRA in that case, and our efforts were discarded, ignored, or rejected, in some cases via the executive secretary rulings that the court have found to be not a lawful practice. And I'll also, just as a non-lawyer, I'm hearing the suggestion to be that PIRA could issue an unlawful decision and then require us to refile, go through the efforts of an appeal, and then refile. And so if a regulator had the sole goal of keeping rates low, all they would have to do is break the rules, and the company would have little to no recourse to get a decision in the manner to which it would be entitled according to the 350-day deadline, and that is a very challenging outcome for us as a company to accept. We have put forth a proposal that we view as legally correct, cost-effective. It is an effort to turn the page and allow PURA, the company's OCC, and every other party to get through this matter in a timely and efficient manner and move on to the remaining work before us, which is important and significant. I think a lot of the questions that were asked today highlight the complexities of trying to take upon these efforts in a new rate proceeding, in a new docket. There's questions about testimony, questions about data requests, questions about motion rulings, many of which were the results of the procedures that have now been found to be unlawful, questions about the protected status of our information, and so much more. I think a lot of these questions highlight the advantages of what we proposed. It is a cost-efficient, timely manner to resolve the unfair outcome of the last proceeding. I will end by commenting on, I know there's a lot of fixation on the quote in the court's decision that we must consider the underlying application anew. As I see it, the application of the companies was the cost of service that we proposed and the rates that flow from that cost of service. And the evidence that we provided in support of that application is all of the testimony, all of the data requests, all of the in-person testimony that we provided at hearing. And it all culminated in LFE 1 and LFE 211 for SCG. And so as we see it, considering the application anew is what we're seeking in our proposal. We think we have put forth a proposal that complies with the court's decision. It's in the best interest of the companies and customers, both of which are wronged by the outcomes that we have today, and we would appreciate a timely and efficient resolution as we have proposed. Thank you.
Thank you. Well, I want to thank all the parties for appearing today at this procedural conference. Based on the discussions that we've heard today, it appears there's not agreement on what evidence from 231102 can be incorporated into a new instant docket. Therefore, absent clarification from the court on how to proceed, the authority must consider the original application in 231102 anew. And again, I want to thank you for your participation. I had intended to take a brief break between starting the 251114 procedural conference, but I suspect much of the information we're going to discuss in that will be similar to this conference. So if there's no objection, I will proceed directly to the procedural conference on 251114. All right, and it's still morning. We are here for docket number 251114, remand of the application of the Connecticut Natural Gas Corporation to amend its rate schedule. And we're conducting a procedural conference. As I said in the prior conference, the Superior Court in the Judicial District of New Britain remanded the November 18, 2023 decision in docket 231102 for entirely new rate proceedings and ordered the authority to consider the underlying rate applications anew as if newly filed. We issued a procedural conference notice on December 22nd, inviting the company and all admitted parties and interveners to provide presentations regarding the procedure. The purpose of today's procedural conference is to address the procedural requirements of the proposed proceeding and to establish again what can be included into the record of this instant docket. Are there any new appearances that I need to take? No. The first agenda item on the agenda is a presentation. I believe you said the presentation was similar. I would like to ask the parties if they would like to adopt in this new procedural conference the answers they provided to the questions in the prior conference. So I will ask the company first.
Yes, no objection to that from the company.
Sorry, I have been informed I need to take appearances again. So I don't want to fail to dot the i's and cross the t's. So if the company can please.
Thank you. Brendan Vaughn and David Martin on behalf of Connecticut Natural Gas Corporation and the Southern Connecticut Gas Company.
Thank you. Office of Consumer Counsel?
Thank you, Commissioner. Andrew Minikowski for the Office of Consumer Counsel, joined by Attorney Allison McCorney and Consumer Counsel Claire Coleman. Thank you.
Thank you. Education and Outreach and Enforcement.
Brittany Wyman, joined by my colleague Jamie Spanhake for EOE. Thank you.
Office of the Attorney General. Department of Energy and Environmental Protection.
Susanna Nigro on behalf of DEEP. Thank you.
Thank you. And Conservation Law Foundation.
Thank you. Shannon Mon on behalf of Conservation Law Foundation.
Thank you. Now, having dotted that I and crossed that T, so you stipulate that your answers would be the same to the questions I proposed. Office of Consumer Counsel.
And just to clarify,
yes.
My apologies, Commissioner Cheeseman, just to clarify that our answers to your questions would be the same, but I think we would prefer to adopt, I guess, all of the statements that we made on the record. In addition to, questions that were comments and things, just to dot the i's and cross the t's.
All right.
The presentation would be the same and the statements and as well, in addition to the responses to your questions. Thank you.
Thank you. Office of Consumer Counsel.
Thank you, Commissioner. Absent further inquiry from the commission, we would simply adopt all of the statements we made earlier this morning in the prior proceeding. Thank you.
Thank you. EOE.
EOE similarly adopts all of the statements made in the prior procedural conference. Thank you.
Department of Energy and Environmental Protection.
DEEP adopts the statements that were made in the prior procedural conference.
Conservation Law Foundation.
Thank you. Conservation Law Foundation is fine with adopting the statements made in the prior conference.
OAG, last call. All right. Anyone wish to make any concluding statements? Any further comment? All right. Well, as I stated in the prior procedural hearing, again, there's not agreement on what evidence from that original docket can be incorporated into the instant docket. Therefore, absent clarification from the court on how to proceed, the authority must consider the original application in docket 231102. All right. I want to thank you all for your participation today. Look forward to where we go on this road. So this procedural hearing is adjourned. Thank you.